So, Ahmed, anything more to add?
My lord,
Anything more to add? You want to add anything more?
that will suffice, lordship. The relief, lordship, that will suffice, lordship. The relief, lordship. And so far as the 2 years condition is concerned, lordship.
That has been done away.
Yes, and
The only thing that the committee had rejected your case, holding that you were appointed as a Sanskrit teacher. But there are materials available on record which shows that although you were appointed as a Sanskrit teacher, there was no post. But thereafter, even in the government affidavit that has been filed by the secretary, there is a statement that you were teaching other subjects also.
yes, lordship.
So in that view of the matter, if you are teaching other subjects and that condition is no longer there, we'll remand it back to because we can't have your case for any other thing now. It has to go back to the High Power Committee. Let the High Power Committee take a fresh decision.
Yes,
We'll only provide that if your case is found to be eligible, then your services have to be regularized from the date people similarly situated were given this.
Yes, lordship.
That's all.
Yes,
And where is that 2-year condition dropping?
2 year condition, lordship, that Assam Elementary Education Provincialization Rules 1977, lordship.
Hmm.
May I read Rule 5
Hmm.
and Sub-Rule 3.
Hmm.
The teachers in the Bhansa school may be retained at the time of taking over if they possess the minimum qualification and age of recruitment, provided that such teachers have put in at least 2 years continuous service immediately preceding the taking over of the school.
Hmm. Hmm.
Rule 5, lordship.
Hmm.
And lordship, therefore, lordship, the two conditions, lordship, one is lordship, the minimum qualification, which I am having, and another lordship is age, which also lordship I am having. And now, lordship, this 2 year condition, lordship, that judgment Jiban Chandra Dekha.
Jiban Chandra Dekha has modified. You have the judgment on record here.
Yes, lordship. And lordship, so far as the one-time exercise was concerned, lordship, that has been once again, lordship, by.
No, there is a direction from this court subsequently to consider your case in that direction.
Yes, lordship.
Where is that 2-year condition?
I'm coming to that, lordship. Lordship, page number 35, Annex 8. 37 would be relevant, lordship.
No, this is your order.
This is my lordship.
No, I want the Jiban Chandra Dekha.
Jiban Chandra, lordship, may I please, lordship, may I please, I'm having the case. Jiban Chandra Dekha, lordship, the first judgment. Paragraph number 4, lordship.
You have the 13/1/2003 on record,
Yes, lordship.
page.
My judgment, lordship.
No, 13/1, the policy.
Policy, lordship, that is not here, lordship. I have not understood. But lordship, that policy was discussed in details, lordship. I have placed one judgment, WPC number 666 of 2010. Harun Al Rashid. In that judgment, lordship, the policy was discussed in
Okay,
details.
got it. We'll remand it. We'll provide for a time frame. And if they find you eligible from the date when the others were so.
And lordship, in the list, lordship, with Hyper Committee, lordship, my name is very much dear, lordship.
But they rejected it, saying that you did not have the requisite criteria and you were against the Sanskrit.
Yes, lordship.
Wait.
Lordship, kindly peruse the affidavit filed by the headmaster also, lordship.
Affidavit, last paragraph, First they say 2 years and then they say Sanskrit and then they say that you were also teaching other subjects. We'll take a
Yes, Lordship.
clue from there and then dispose it.
And Lordship, at that point of time, Lordship, there was no post of Sanskrit teacher in the school, Lordship.
If we'll say that when the posts are created in a venture stage, it's
Yes, sir.
for the managing committee to do it. Government has no connection there. Anything more?
And Lordship, if we go by the Rule 5, Lordship,
Hmm.
the condition for taking over elementary schools,
Page,
this book, Lordship, 303. Conditions for taking over elementary schools. Once again, Lordship, may kindly allow me to read clause number 3, Lordship. The teachers in Bhansai school may be retained at the time of taking over if they possess the minimum qualification and age of recruitment. Lordship, these are the two conditions, Lordship, which I had to.
and this have put in at least 2 years of
2 years,
continuous
Lordship. That
service.
has been
That
relaxed,
was
Lordship. That has
subsequently,
been relaxed. And so far as the qualification part is concerned, Lordship, may kindly come to Rule 3, Lordship.
and one thing they'll have to look into whether the teacher-student ratio also at that point of time was.
Yes, Lordship. Rule 3, Lordship, the qualification part. Page number 296, Lordship.
Hmm.
Age, then qualification. Lordship, may kindly the last line of the page, Lordship, qualification,
Hmm.
last line.
Matriculation shall be the minimum
Matriculation shall be the minimum
is your
qualification for the, at that relevant point of time.
What is your qualification?
Matriculation.
Thereafter you took up. No, you are matriculated.
Yes, Lordship, I'm matriculated, Lordship. Matriculation shall be the minimum qualification for the post of teachers in elementary schools. So, Lordship, my submission is that, Lordship, I had that all the qualifications, Lordship, to be retained as a teacher.
Item 2 for admission.
Highly applies.
Yes, Mr. Panik.
May it please your lordship.
Hmm.
At the very outset, my lord. At the very outset, I concede that it's 42 years late in the day. But what I'm trying to submit before your lordship is that if I may try to persuade my lord to take a view as to what the Honorable Apex Court had distinguished in context with correction and change, then regardless of the fact that I'm at the fag end of my service, or I will be retired soon, or I'm not in service,
You have siblings?
my lordships,
You have siblings?
I did not put that question. I'm extremely sorry. My lord, what I'm on is that this,
See, that material that you have brought on record
my lordships,
says that a daughter was born.
my lord,
Now, naturally, on that day, you did not have a name.
correct,
You had a name subsequently.
correct.
So that daughter is you. It's a presumption.
Anyways,
That's a presumption.
that's a presumption.
Whether you had a sibling or not, or you don't have any sibling.
No, I can find that affidavit. I do not know. Presently, I do not know. As a lawyer, I do not know.
Get it? Secondly, you were admitted in your school, in the
My
school,
lordship,
sorry. You were admitted in the school
my lord.
by your parents who were alive at that
Correct,
point.
correct, correct.
But they did not give a date, which was akin to the date which is now recorded.
Correct. Correct.
So it's not a case that you were not admitted in the school by your parents. You were admitted in the school by your parents only.
Absolutely. Absolutely.
So there is no explanation on record to show as to why that date,
Correct. I got
the
it.
parents
66.
will never forget that day.
Now, if I
And your parents are educated people.
educated, if I may address my lord on that. Look, it would be too broad to say that such corrections should be allowed on the technical interpretation of law or should not be allowed. Rather, should not be allowed is more favorable to the society because it can have a lot many continuous changes to follow. It may have. Now, as a lawyer holding the brief, I may argue it in a different way, but as an officer of the court, I would like to be absolutely neutral on it. When a child is born either with contemporaneous hospital records or otherwise. Once hospital records are there and the hospital is a government hospital, it validates the birth and the parents from which the child is born unless a dispute is raised that you are not the child born out of that, on that date for that parents. So that part is gone. Now, so far as the school records are concerned, the person whose data are incorporated in the school records, at the relevant point of time, he or she has no say. As the person grows up, there's a tendency to believe that my parents had put in the correct thing. And so I served my entire service career also. It's a different thing. I'm a government servant. I might not have been also. Now, once my father died, I get hold of a document to show that it is not 66, it is 64. May I pause for a moment, my lord? I do not take the benefit of 66. I want to go to 64. Thereby, I do not add any advantage to me. Rather, it's to my disadvantage to go to 64. If I stick to school records, then perhaps I grow younger by a change or a correction, if I put it that way. But if I go to 64, I go with the truth and nothing but the truth. So what do I do? In my pursuit, I approach the hospital authorities as also the school, the SEBA. In the SEBA, I indicate my correction to be the school records. But then, wisdom plays a role. Because at the fag end of service and life and at this age, I do not want to go this way, that way. I go to the hospital, get the correct records and say, no, I should be older, not younger. It's 64. Kindly put it that way. Now comes the bar of limitation.
No, you have two dates of birth before me today.
School, hospital.
One is 16/7/64. Another one is 24/6/1965.
Correct.
So if we go by 1965, you become younger.
So if I go by 66, the school record, I become far more younger.
No,
School record says 16/7/66.
okay, fine.
I do not want to go by that. What I'm on.
We go by 16/7/64 that is recorded in the matriculation.
Very well. So if
You
I,
have not disputed that.
I have not disputed that. What I say is that now, since authentically, I have legitimately got hold of a document which says 65. Would I be permitted in law to effect that change or correction as it may seem? My lordship, I am on the rigors of the period of limitation. They still can deny it, saying that no, we will not allow such a case to follow. When you dispute with the school records, maybe you have a genuine, I would not. But prior to that, there is a bar of limitation which I have to address and overcome. This period of limitation, my lord, is regardless of whether I am employed or not. It only matters when I have raised this issue for correction. And I must say with all humility and responsibility that the Apex Court has held the 3 years to be a valid prescription. That we have given the list of books, my lord. 2003, volume 12, Supreme Court cases, page 408.
Regulation 8 was interpreted there.
It says it's valid. Now, once 2003 8 SCC holds the fill, it's valid, then I have no case. I have no case from 2003 container. From 2003, I have no case. But for Jigya Yadav, I might be able to persuade my lord to take a larger view, not only in context of this case, but of n number of cases or situations.
We have been doing that.
Absolutely.
We have been doing that. Together we have been.
I appreciate my lord, they hold a view against, that's fine.
Now, tell me one thing. We have a date of 64, which is the matriculation date, which again emanated from the MRS, that is the school records.
Yes.
We have a date of 66, which you claimed before the Board of Secondary Education, right? And we have a date of 65,
Correct.
which you claim is the date of birth recorded in the hospital. Now, when you went for correction,
I gave
Before the-
66,
you went with 66.
66.
65 was never a part of
Never a part of it.
then.
Absolutely. That is what I'm addressing, my lord.
65
Correct, correct.
come in
Correct.
first proceedings.
Absolutely correct. Once we gave 66 there, and the response was not forthcoming out there. This we had document 65,
When was your application before the
16, 6, 12, 22. Page
before the
18 of
SEBA
the writ petition.
page?
18 of the writ petition.
I know the page 18, man.
Vice 2022. Here is my actual date of birth. He says 67, 1966.
Correct. That's by the record. What
Just
What
a,
is this?
just a minute.
And then a piece of paper pick up from a hospital. He says 65.
We are not on that.
No, I understand.
Now, page 18,
18,
18 was preceded by page.
Correct. I get it what your lordship
30.
says. I get you what lordship says.
Then Why
is-
did not, why did you not use?
This is
65?
absolutely correct, my lord. Even I had put the question to my client. We came up with fairness that now,
Mr. Bonik is always fair.
no, I am. But what I am on is that we did not shy away with the truth. We went to 66, but we had 65. I lay before your lordship that technical objections may not come. Either I am stopped by limitation, the bar of limitation is there, or it's not there. They can still refuse. Rather,
Your conduct, what did you say?
I leave it to your lordship.
Your
I
conduct.
absolutely, because by
When you
choosing
have-
64
And now you are harping on Jigya Yadav to bring on the point. That
limitation,
see, 65 is a public document. And that public document has to be given a meaning. That's it. Jigya Yadav,
I would happily go down if lordship reads it this way. You applied 66, you had 65 a day prior. I mean, couple of days prior. You did not press into service, whatever you may say, but it does not come from the record that you had put it. In response to that, I bow down that yes, it ought to have been 65, it was given 66, but having chosen 65 over 66, I do not stand to gain.
you stand to gain.
I do not stand to gain, my lord. With all
66.
this, 66 and 65. If I go by 66, I am younger. If I go by 65, I am not so young.
No,
I
it's
lose
not,
a year.
it's not a question of being younger or elder. Your cutoff, your age
Age.
was cemented as 64.
64.
Be it 65 or be it 66, you stand to get an advantage in your service career.
Both ways. But we chose, by the hospital, we
But,
chose to be,
but you had now 2 extra dates with you to elect.
one by parents, one
No.
by self.
No, one which you say from court
School-
record, school records,
school record.
and one from the
Hospital. record.
hospital records. Now 65, 66.
I should have gone by 65.
If you had gone by 65, made an application,
Correct.
then that Jigya Yadav would have applied subject to the application of discretion by this
Correct.
court,
Absolutely.
delay. But now see, 65, 66.
So I get your lordship's point.
You to take a more advantage in your service career,
No, no,
You
service,
went-
I'm out of service, my lord. No, I'm not on the service part at all.
You are, this will boil down to your service. I told you the other day,
I know, Chief.
you tell me that with this, you are not going to take any advantage.
As a
of your
lawyer, I
service.
cannot make that statement.
Then-
It's beyond my
Then
belief.
you make that statement, I am coming in. 65, I am giving it to you.
As a lawyer holding the brief, my lord, of correction of or change of date
That's
of
what
birth,
I told you the last two.
I understand.
You give me a statement.
Right.
We will record it. That this is my date of birth. I want it corrected, but I undertake because of the facts here, not to take advantage in my service career.
But
That's the end of the matter.
That
for
would be
discussion.
slightly traveling beyond the brief 4-5. I am concerned, my lord. What I am on is
That's
that,
what I told you the last day.
what the proposition I was on is that lordship may dismiss my case on 2 grounds. But as I could see, there may be n number of grounds. One, why did you go for 65? I put it to myself, you ought to have said 66, you ought to have gone 65. Whatever, even they told me no, go by school record. I may have an explanation. But then you should, although you don't stand to gain, but you should be clear. You have the hospital records.
This 65 choosing, you have not justified in your writ petition.
Number one. And number two, it may have a bearing on your service since you are a service holder. At this point, Mehul, what I submit with all respect is that there is no bounden duty on the SEBA to allow my application. The only embargo is that whether they are within the time zone to consider or not to consider.
Let's say, Jigya Yadav, we say, correction of these things. Change or correction, whatever it is. It's a correction basically.
There is no sense for date of.
Huh?
Only correction.
Change.
Let's hold it. Jigya Yadav. We are broadening it, Mr. Yeah, for Mr. Boni. Now we apply. But here also, we are comforted with 2 days, extra days.
I have a submission there, which I
65
didn't have the earlier version. There is a submission here, Mehul, a legal submission to follow. In the earlier question, which had fallen from your lordship, that why you didn't give 65 or 66, although I may say that they wanted me to give the school records, but that would not be a legal submission. That would be a factual submission. Here I am on the legal submission. Once we go by Jigya Yadav decided a lot many batch of appeals were somewhere related to names and surnames. I do not use the word correction or otherwise, and some were relating to date of birth. The fallout was in a particular paragraph, just 160. 160. May I read 160? Just the opening line. The conditions regarding correction in name or date of birth are not as stringent as conditions applicable to change thereof. May I read on further, Mehul? For correction in the name, the 2018 bylaws provide for a limitation period of 5 years and permit such corrections that can be characterized as typographical, factual, or spelling mistake in comparison with the school records. Understandably, a correction would mean a retention of the original record with slight modification to make it consistent with the school records. The requirement of modification could be born out of various reasons, namely typographical mistake at the time of publishing, spelling error, or factual error. That
Up
is,
to 161.
I'm coming. Similar provision is available for correction in the date of birth, either on the basis of school records or on the basis of order of the court. The word change is not used for date of birth, as unlike there can be one date of birth and there can be a correction made inconsistent with the school record or order of the court. It cannot be changed to replace the former fresh date of one's choice. I am on this, Mehul. This is not a matter of choice. This is a matter of a contemporaneous document where presumption can be taken by the court to be a correct date of birth. I am on that.
Seba with 65.
No.
Then how can?
Would my lord allow
the
me to do
prayer?
so? Would my lord just allow me to do so? Regardless of my age, that I may apply, because in context of 65, the entire case is proceeding before your lordship. My lord, I may lift, the curtain may go that the sheen remains. Page 1, paragraph 193 or 193(1), my lord. I invite my lord's attention.
And see, it's not change with regard to date of birth, it's correction.
Absolutely. I'll justify both the points together, my lord.
Hmm.
I cannot have a date of birth of choice. Any day, any forum, any case. There has to be only one date of birth. But as we read the judgment, which also discusses the Assam case
Hmm.
regarding the limitation period, it says, and with no dissimilarity on that, that if I am relying on school records, it's a correction and I am within the bar of limitation. And if I'm not relying on the school records and I'm relying on a public document, which is a date of birth, I mean, from the hospital records, otherwise,
Show me that.
minor. Page one, paragraph 192 onwards. We are on the particulars of the certificate by the board. We're not on the name or date of birth. Page 192, paragraph 192, if Lordship is there. May I read? Although we have discussed the broad issues canvassed before us, in the ultimate analysis, the real dispute requiring resolution is about the nature of correction or change, as the case may be, permissible to be carried by CBSE at the instance of the student, including past student. As noted earlier, broadly, two situations would arise. The first is where the incumbent wants correction in the certificate issued by CBSE to be made consistent with the particulars mentioned in the school records. As we have held that there is no reason for CBSE to turn down such request or attach any precondition except reasonable period of limitation, and keeping in mind the period for which CBSE has to maintain its record under the extant regulations. While doing so, it can certainly insist for compliance of other conditions by the incumbent, such as to file sworn affidavit making it necessary declaration and to indemnify the CBSE from any claim against it by the third party because of such correction. The CBSE would be justified in insisting for surrender, return of the original certificate or duplicate original certificate, as the case may be, issued by it for replacing it with a fresh certificate to be issued after carrying out necessary corrections with caption annotation against the changes carried out and the date of such correction. It may retain the original entries as it is, except in respect of correction of name effected in exercise of right to be forgotten. The fresh certificate may also contain disclaimer that the CBSE
Okay.
cannot.
Make your submission. So, okay, I got it.
Now 194.
I got it.
I am on that, Milord. Am I to be thrown out only for the fact that 66 and 65 the application, or am I trying to make out a case regardless of whatever outcome they may
See,
consider?
194 has to be read in the light of
I leave it to you.
193.12 lines.
I leave it to your lordship. I
Anything
break
more?
that context.
Anything more?
And if they would further on this context, Milord, if I apply, if it follows that strictly, would I be permitted to apply for an age of 65
We would have, if that certificate would have come on a
later?
date post.
Post. I get it. But I leave it to that much because
That shows that you wanted to take an advantage.
that would not show that because
And they have filed an
But
affidavit.
if
They have
that
filed
goes
an
that way-
affidavit, and therein they have brought the school records.
oh, we say it is there. We do not deny it is there. We say it is there. Once we say it is there, we do not rely on it to effect a change. We rely on the hospital records. One thing further, Miller.
Hmm.
Since it's a court of equity, and I'm not asking for the moon, may I be permitted to afresh submit a representation that would make things fall in line, Miller? Perhaps
Not if we have to come on merits.
On-
If we have to come on merits, we will not permit you.
no, not on merits. Not on merits. Not on merits. Absolutely on the face of it. Since on touchstone of that, let the person have a chance. Let them still strike it down. On that. It's there, 66 is there. We do not dispute that it's not there. That much would give a breather to the client at this stage, Bino. Not on merits. I put it that. I rest my case.
If you have to do that, you will have to withdraw this writ petition.
Can I come back after the election with the instruction?
Today.
Today, when I get across, with the liberty to approach for 65, very well. At two,
Subject to what? Mr.
absolutely, subject to what he says. They still have the feeling.
But there will be a rider subject to limitation. Earlier applications. It won't be an open,
No, no, what I am on is that,
it won't be an open liberty.
what I am on is that if they in pursuit of
Yes, Mr.
deciding the application,
Chutia.
Doctor, is a case is under 226. Itself a disputed fact, they have made it, madam. We are not making.
You are not,
They are making 166, 165, 164.
no, even more than that. They
All
had
the-
65 with them. But they went for 66.
66.
That shows that
The
she's trying
benefit
to
of,
take advantage.
Lordship, correctly, ballot, assuming the benefit of service. And he, at that time of ballot, he applied it 22. Even our, this regulation doesn't permit it beyond 3 years. And if we take it 65, he will be 14 years in 1980, he underage.
Underage.
Then also he cannot appear. How, what is he remain in the case, my lord? Why he taking time, my lord? For instruction, what instructions, sir?
No, no, no.
well, that was a different conversation.
Lordship will pass an order, my lord, Lordship,
We'll pass orders.
yeah.
What is this? I is this possible? Mr. Bonik, well tried. Can't help it.
Be given more time.
Your conduct. I can't ignore.
I already made my way in,
Well, well.
except for their application, my lord. I had made my way in, except for their application.
But he.
I mean, Jigja Yadav can be read the other way also. That's what I was trying to say.
Jigya Yadav, the understanding of this court,
In a given case,
in a given case,
I know,
wherein we
I'll come
could,
back again, my lord, in a given.
wherein
case.
we could,
Not sure.
we have already,
I understand.
we have already,
Jiga,
I think around 4-5 judgments are there.
Jiga Jada 161, paragraph, not change, correction. Obliged, my lord.
Obliged.
He is outside the court, he will say, my dada, I am trying.
What is known?
Say, he is outside the
Mr. Bonik is a fighter,
court.
and we know that. So we hear him
Yeah, that's it.
because
Patient hearing, my lord.
he gets propositions which are attractive.
Yes,
And I appreciated that when I was that side also.
anyhow, my lord, he tried it.
But he did it before a wrong court, maybe. This was.
Obliged, my lord.
How many?